say anything, let me know. The way our procedures work is that I will be asking the questions, and minority party will have an opportunity upon request to ask questions as well. I've discussed this with the minority whip, Senator Jones, and he may or may not ask questions towards the conclusion, or maybe even at a break. If you want to, just let me know. Ms. Merchant, would you please just identify yourself and let the committee know? You see all our name tags to see who's on here. You know who we are, but let us know who you are and what your profession is, background, etc.
Definitely. My name is Ashleigh Merchant. My first name is spelled A-S-H-L-E-I-G-H. Last name Merchant, M-E-R.
You're going to need to pull that mic a little closer to you.
Thank you. And is it okay? I have a notepad just in case I get two questions at the same time. I like to make a note to make sure that I remember.
The committee knows the rules. We passed them unanimously at our last meeting, and you actually have the right to counsel if you want to. It's not like a court proceeding where we're going to be having objections, etc. But since you are an attorney, apparently you're very comfortable responding. Okay, yes. Didn't mean to cut you off. Let's just make sure everybody can hear you there.
Thank you. Yes, I'm a criminal defense attorney. I was sworn in as a member of the bar in 2004, so I've been a criminal defense attorney for 20 years. I started out when I first graduated from law school. I came to Atlanta and I did an externship with the Southern Center for Human Rights, and then once I was sworn in as a member of the bar, I became a public defender in Fulton County. I was there for 4.5 years until I started my private practice, the Merchant Law Firm. We had an office in Fulton County at first. Now we're in Cobb County. I'm in practice with my husband, John Merchant, and we do criminal defense primarily.
And do you have any other roles or affiliations? I've seen just press articles about you.
Yes, yes, so I do. I've been very blessed to have a lot of active roles in the community. I was the former president of the Cobb County Bar Association Criminal Defense Section. I was sworn in January as the president of the Georgia Association of Criminal Defense Lawyers. I've been a member of that for 20 years, member of the Cobb County Bar Association, very active in both of those roles. I've been honored with several different awards, one from the Cobb County Bar Association, Defender of Justice, or Champion of Justice, I'm sorry, a couple years ago, and then, I've been honored with Rising Star Awards, Super Lawyers, and the Daily Report has different awards back when I was younger, 40 under 40. Wouldn't qualify, unfortunately, for that anymore. But, and then recently I was awarded at our annual meeting for the Georgia Association of Criminal Defense Lawyers. I was very honored to receive an award about my work defending the Constitution.
Okay. So you are the current president of the Criminal Defense Lawyers Group?
Yes, yes, and it's the Georgia Association of Criminal Defense Lawyers. We go by GACDL. We have about 1,500 members right now. We're aiming to get around 2,000, but we're one of the largest defense bars in the country.
And tell us a little bit about your trial experience over these last 20 years.
So I started doing post-conviction work, which is, after a person is convicted, doing appeals and habeas work. Then I went into misdemeanor trial work at first when I was a public defender. I moved into the complex felony division, which is where the majority of my practice has lied. I do about half of my practice is appeals, appellate work in the Georgia Supreme Court and the Georgia Court of Appeals. The other half is trial work. I specialize in complex felonies, so anything that's mostly in Superior Court. Every once in a while, I'll have a client who has a state court case, and so I will end up helping them on that, but primarily complex felonies.
All right. And during the course of your practice here in the Atlanta area, tell us a little bit about your involvement, and I'm just going to refer to these as the election interference cases. I think there's 16 or 17 defendants. You are involved in those cases, I know from seeing the news.
Yes.
Who do you represent?
I represent a gentleman named Michael Roman. I was hired late August, early September, around, I think it was late August, to represent him. He lives out of state, does not live in Georgia. But so I've been his defense attorney since the time of indictment.
All right, so late August or September of 2023?
Yes, I began working on his case in late August of 23. I think I looked this morning, I filed my official entry on September 1st of 23, and then I negotiated bond for him, walked through the turn-in process, and began negotiations with the prosecutors.
What exactly is he charged with? What's the offense he's been charged with?
He's charged with conspiring attempting to violate the Racketeering Act, so RICO. He's also charged with some of the more specific allegations for him are attempted and conspiracy to file false documents. So essentially, I've classified the indictment. The easiest way for me to classify the indictment is there's the folks that are federal officers, there's the folks that are charged in the alternate elector process, and then there's Coffee County. He's in that middle section.
So that's the alternate elector process?
Yes.
And those are the documents that are deemed to be false there?
Yes,
Okay.
that's what he's charged with. He's charged with false, filing false documents, false swearing, things like that, forgery.
And to be clear, you do not represent any of these alternate electors?
No, I only represent Michael Roman.
And you don't represent Donald Trump?
No, I do not represent Donald Trump.
Your involvement in the case is just for Michael Roman?
Yes, exclusively Michael Roman, and that's my duty.
You have produced quite a few documents to us.
Yes.
Do you have any concerns as to whether any of those documents are protected by attorney-client privilege?
I don't have any concerns about that. I do have some privacy concerns because you mentioned earlier that there was some financial documents that are not redacted, and so those would need to be redacted. That would be the only thing, but they're not. Phone numbers, I believe I redacted all the phone numbers, but there are some financial documents that are probably sensitive.
Okay. As far as Mr. Roman is concerned, is he giving you permission to speak freely about his case and about the evidence or documents you've accumulated in the course of his defense?
Yes, we went over the subpoena that I received and the classification of documents that I was asked to give. All of those were things that I obtained through discovery, not discovery from the state, but through my own. So we have a protective order in the case. So anything that I've obtained through the state could potentially be subject to that protective order. But these were all documents that I obtained through my investigation.
Okay.
From the #1 rated brand in cordless outdoor power, the Ego Power Plus blower, reaching an...
Most of the members of this committee are attorneys, but not all.
Okay.
And I recognize that the general
This
public
is
will be
Ashleigh
hearing some of
Merchant,
this
Caleb.
either now or later.
She testified in front of the Senate committee about Fani Willis, okay, and Wade. Okay, now you have to pay attention from all.
Yeah, definitely. So we have a statute in Georgia that allows us to do what called opt-in. So if we opt into the discovery statute, that means we're engaging in reciprocal discovery, which means that the state has to give us a copy of all of the material that they plan on using at trial. They also have to give us copies of anything that would be arguably exculpatory. And so in this case, there's been a lot of discovery exchanged because obviously there's a lot of defendants. And if they wanted to classify something as sensitive, they would do so. And then if we wanted to be able to disseminate it to any third party outside of our practice, we would have to have court permission to do that.
Yeah.
But when we are investigating a case, not everything comes through discovery. So in general, I would investigate a case on my own, and those items are things that I did not receive from the state. So we've got different classes of documents. The documents that I actually received from the state through discovery, through formal discovery, and then documents that I developed on my own.
Okay. And out of these documents that you've obtained from the state through formal discovery that they're obligated to provide defense attorneys to fairly defend your client, some of those have been deemed to be sensitive and that are not freely disseminated?
Yes. The state, how the protective order works, and the protective order is public. It was publicly filed. If the state deems something sensitive, they let us know that. And if we dispute that or we have some reason that we want it to be able to be disseminated, we would have to go to the court and basically argue over that.
Fair to say any of the documents you have provided to our committee were things that you obtained outside of that formal discovery process and are not subject to any protective order?
Yes, I did not. Nothing that was subject to the subpoena or that I provided was something that I got from the state. And nothing was subject to that protective order. I went through and was very clear on that.
Okay. And I'm wanting to make sure of this because this committee has made it clear from the beginning it is not our intent in any way to interfere with the criminal prosecutions. And so I would not want to be circumventing a court order that was for the protection of the privacy of the parties to that case. It is not our job to interfere in that case at all or in your motion to disqualify Ms. Willis.
I appreciate that. And I was very cautious because I certainly don't want to go against a court order protecting, so I did not disclose any of those documents.
So tell me a little bit about the special grand jury process. It sounds like that occurred before you were ever even hired in this case.
It did. It occurred, and my client, Mr. Roman, was not involved in that at all. So he was never someone that was issued a target letter or a subpoena or contacted. So he was never involved in that either. So he didn't have counsel, obviously, since he was never involved in the special purpose grand jury. But in my role defending him now, I've obviously reviewed all of the things that happened with the special purpose grand jury that I have access to. So it's my understanding Ms. Willis obtained an order from, at the time it was Chief Judge, I believe it was Judge Brasher, who was the Chief Judge at the time, obtained an order to impanel a special purpose grand jury, and I followed that in the news before I was involved in the case because it's very unique. It's not something that happens very often. Normally when we see a special purpose grand jury, it's some type of investigation into a jail or something like that. So it was kind of unique to see that. But from reading everything, my understanding is a lot of the witnesses weren't willing to necessarily talk without a grand jury, and so that's one of the reasons that they had to impanel a special purpose grand jury. But it was very unique.
I've been practicing here a long, long time, and I haven't seen a special purpose grand jury to basically advise the DA, apparently, or a subsequent grand jury as to whether there's evidence to prosecute. Is that essentially what it did?
That is exactly what it did, yes. So, and now through the discovery process, I've been able to review a lot of the transcripts and also talk with a lot of the lawyers who were involved and witnesses that were involved in the special purpose grand jury. But that's what they did. They used that process to subpoena, particularly out-of-state witnesses. So in Georgia, it's always difficult when we have a witness who's out of state because we have the interstate compact. We have to get a certification to get a witness subpoenaed from out of state. It is not easy. It is one of the more difficult aspects of our job. So they used the grand jury process, the special purpose grand jury process, to bring in testimony and bring in witnesses from out of state. They issued a lot of target letters to people back and forth. That there was a lot of people that were targets and then weren't targets who testified, maybe negotiated some type of immunity, things like that throughout that special purpose grand jury.
Okay. And is that made public to other defense attorneys if immunity has been granted to any witnesses?
I don't know if it was made public originally. I know that some of it has been provided to us through discovery. We had a motions hearing where the judge ordered that the state give us copies of transcripts because they had everything recorded. So there's a transcript from the special purpose grand jury. It's my understanding there's a transcript from just about everything, but it does appear like sometimes that was cut off. So there are some sections that were recorded and then maybe a section wasn't recorded and then they went back on the record. But it was recorded, which we rarely get in a regular grand jury. We rarely, if ever, get that type of testimony. So that was very unique to have.
Is the state required to let you know if they've granted immunity to any witnesses that may have been utilized in the special grand jury process or in seeking the indictment?
Yes, they are. And, some of that has been given to us through discovery. Some of it has been given to us from other attorneys, the attorneys who maybe represented those parties. There was a lot of back and forth. There were a lot of, and this, I believe this was all public, that some of our state representatives, I think the governor in particular, were subpoenaed, and there was back and forth over who could grant immunity, who had the power in that office to grant immunity. And that's something that I reviewed in my work on this motion with the DA's office, because Mr. Wade was the one that took over that power. And so the emails that were attached to a lot of the pleadings, it was interesting. It first started out that there was someone else in the DA's office who's actually an employee of the DA's office who was negotiating all of that. And then it evolved to another member of the DA's staff, and then ultimately it was Mr. Wade, and there's emails where he said, I'm the only one that can grant immunity. I'm the only one that has the power to do this. I'm in charge.
Was he engaged or involved in the special grand jury process?
Oh, very much so. He was by far the lead of it.
And do you have the timeline of when that special grand jury was authorized and when it began to meet?
Yes, I don't know the dates off the top of my head, but
Where
there is
the
an
paper?
order, and I can review it. I brought some of the pleadings with me, but it was authorized
Where the paper?
Sometime, so he was appointed, the timeline, he was appointed in November 2021 to work on this case. It was sometime after that Ms. Willis sought the special purpose grand jury and got authority to do that. And then that went through, several months, and then they issued a report to her.
So he was hired by the Fulton County DA's office before the special grand jury was authorized or
Yes.
impaneled? Okay. And so he was involved from the very beginning of that process.
Yes, and he was actually hired, I believe, before it was even, I know it was before it was impaneled. I believe it was before the order was even issued, though.
And do you know what his role was as what's the official term? A special assistant district attorney?
It's a good question. I'm not sure. He usually goes by special counsel or special prosecutor. I don't believe he goes by special assistant district attorney. I don't think he's permitted to do that. I've studied these statutes a lot, and there's no real term for it. I've heard him go by independent counsel, things like that, but I don't really think independent counsel would be an appropriate term because he's not independent. So I've studied, I did not know this before, but I've studied, the structure of the independent counsel in the federal system. They're actually a separate office. They have their own appropriations to have a separate office, and they are kept separate from the U.S. Attorney's Office. So that would be where you get the independent counsel term from, or independent prosecutor. He goes by special usually, so special prosecutor or special counsel. And I think that's because he's not independent.
Is this commonly used in the state of Georgia? I don't know the scope of your practice. I'm not familiar with DAs doing this often.
No, and so I do practice throughout the state, and I've practiced in almost every county in the state at some point in my career, and it is very rare. I've had instances where there is special counsel, but those are very limited, and I can tell you about those, and then I can also tell you what I did to investigate that, because I had the same question. So first...
Just so you'll know why we're asking, the scope of this committee is we've heard a lot of the allegations, and you, as a matter of fact, made most of them, or made
Right.
some of these public, and there's of course a public, outrage or uproar or concerns about some of the alleged improprieties that you have brought forth, both within the in the system, kind of what's appropriate conduct, and also financial improprieties. And we're tasked with investigating and finding the true facts, and not just taking the press at face value. And that's why we're asking you for documents, et cetera, so
That's
we can
right.
independently
Documents.
verify the various allegations that have been made. But we're also specifically tasked with, if necessary, amending existing statutes or creating new statutes to build guardrails or whatever to essentially restore the public faith in our criminal justice system.
That's right.
In its impartiality and its fairness. And I have looked at some of the existing statutes, but it's very sketchy. What is the real authority? And we wonder if we need statutory authority or statutory limitations. And so I want to explore with you a little bit what the authority is for a special grand jury to be conducting a criminal investigation, and also the use of a special assistant district attorney is what I'm referring it to. But and so that's the context. You have done that research, so help walk us through this just a little bit. Is there a statutory process that gives authority to utilize a special grand jury to advise a DA or to essentially accumulate evidence for a DA to determine whether or not to indict?
Right. So the first question was about whether this happens throughout the state or not. I did do open records to every single district attorney in the entire state of Georgia to find out, because I wanted to know, I knew based on my practice that it was a very rare process, but I wanted to know, I wanted the data. I wanted to actually see it. So we did an open records for every single district attorney. We have received responses from almost all of them. There's only a couple that we haven't, but I don't know that those would be big factors. The few that were remaining, I think it was Augusta that I haven't received one from. But I talked with two of the prosecutors in those districts. There's only two that actually use something that would be akin to this. And one of them said they haven't done it in years, but they have done it. and they pay between $1 an hour, which tends to be about the going rate for appointed counsel. It's between $40 and $60 an hour, I know, for appointed counsel in most counties. And then the other county that did use them, they use a part-time solicitor. And that DA said every time that they would have maybe some overflow work, an appeal or something that they had extra work to do, they would hire this part-time solicitor. So it was someone who was already a government employee, and they would pay $45 an hour for this person to do work. So those are the only people. This is a very unique to Fulton County, which I assumed, but I didn't know until I did the research. Nobody does this but Fulton County. And the AG's office does it, and so we got a lot of arguments from the state about, well, the Attorney General's office does it, but that's a whole different statute. It's not even the same section. So the Attorney General is authorized because they represent all of the state agencies. They are authorized to hire outside counsel, and they have to because there's a lot of conflict issues, and so it makes sense. So you've got different needs for hiring outside counsel. You've got conflicts if there's a conflict, and if there's a conflict, you'd have to hire someone who's
trying to
outside
see
the
how
office.
you get all the
couldn't hire
information.
someone like in this case, like Mr. Wade, to be special counsel because they're in the office. So you can't, when you have a legal conflict, you have to have, the offices have to be separate. So with the AG, that's usually what happens. Sometimes it's specialized knowledge. I mean, you've got people who are representing commissioners, you've got people who are representing people in certain agencies in the state, in certain types of power. And so it might be a specialized practice area. So the Attorney General is authorized, and they actually publish it on their website, all of the rates. It's very transparent. So I went through and looked at everybody's rate. I mean, it's very transparent. How much they pay, it's based on experience. They get approval for that. They get approval for the appropriations for it. And it's just extremely transparent, which is in direct contradiction to how it works in Fulton County.
And do you know how many judicial districts we have in Georgia? I don't.
I do not. I could look at my open records request. So the judicial districts, there would be a district attorney for each of those. And so those are who I sent all of this.
It's over 50.
It's over 50. I think it's 59, but I'm not positive.
That's what I think.
I think it's 59.
So out of those 59, you reached out to all of them to see if their district attorney's offices for each judicial circuit ever utilized a special assistant, outside counsel.
And because
excuse me,
anyone with $10,000 or more in credit card debt or personal loans may qualify for help from National Debt Relief. Getting started is easy, and the process has already helped over 500,000.
it's somebody from outside, and
Let me take it back. Here we go. Because I got to hear this. I'm sorry. My fault.
If Ms. Willis had hired a employee, one of these 55 employees, and tasked them with the job of going through a special grand jury process and helping seek indictments, investigate these allegations, what's the most they could have made?
well, first, she couldn't have hired Mr. Wade because it violates county policy. So she would not have been able to hire Mr. Wade as an employee.
How does that violate county policy?
They have a lot of policies on nepotism, relationships, personal, there's a lot of guidelines in the county policies. So she would not have been able to hire him.
You still didn't answer his question.
It would not have been approved. And that would be something that actually did have to get approved by the county. And because of their relationship, that wouldn't happen.
So she wouldn't have been allowed to hire him because of violations of other county policies?
Yes.
He couldn't have been a direct employee of the district attorney's office?
Exactly. He could
This
not.
process circumvented those rules and ethical obligations?
Yes, it did.
Let's say it wasn't Mr. Wade.
So if it wasn't Mr. Wade and someone else, I believe most of the other prosecutors on this case make around $175,000 annually.
I interrupted you, I'm sorry.
That's okay. No, that was the answer. So, you know, if she had hired Mr. Wade or somebody else as a salaried employee, they would make around $175,000, most likely.
So using this technique that didn't obtain approval and didn't have to follow the ethical guidelines of her own office, she was able to pay him $700,000 over 2 or 3 years.
Yes, and
Way more than he would have made as an employee.
way more, and also he's able to have a private practice, which is significant because you're not able to have a private practice if you're an employee. So that's a big issue.
Have you reviewed his billings?
Yes, I have.
Senator Dolzall, will you give us an example of one? I think we have one we're just going to pull up randomly, kind of. Okay. Is that an example of the type of invoices he would submit?
Yes, it is. And so
That's an actual one, isn't it?
that is an actual one. And so there's a couple things on this. You asked earlier about the authorization, that stamp that says okay to pay. I believe that's Dexter Bond's signature. So that was one where, Ms. Willis didn't approve it or didn't review it, at least as far as we know from the signatures.
But her chief legal officer did.
Right. So they would do that stamp okay to pay, sign it, and then send it to processing. But yes, this is one of the bills. And so he had monthly caps, which went up. There were a couple different contracts that were renewed. So he had one contract that expired, another contract, and the monthly cap was $35,000 a month. So that's where you see the total. But this billing is not something that you would normally see.
All right, well, I'm noticing it lists the day and just a number of hours. There's no real itemization of exactly how much time you spend doing whatever type of task.
Right. There's none at all. And I also open records because in Fulton County you have a badge to access everywhere. So I didn't open records for his badge access. I was told he didn't have a badge. I was told by other witnesses that he did. So, I don't know. But that you would, if you were doing these things in the office, you would. I used to be a Fulton County employee. You have to scan, and they keep track of all of that. So you have to scan your badge to get in to certain places. So if he's doing this, even as a contractor, contractors at the jail have badges. The medical providers have badges.
Come
They
on,
all
we
have
know
the
that.
badges
We know
they
that.
scan. I open records to the sheriff and the DA's office, and both of them told me that he did not have a card, an access card. But in order to do this, I would assume he would have to have one to get into the DA's office, and I have been told that he had one, and those you'd be able to see when he went in and out. But I was denied that.
Anything unusual or irregular about, this is just an example, Bill, about the way he billed the county?
Completely. I mean, you would never see this. This is what I would call block billing. So one of them, for example, it's 28 hours over the course of 2 or 3 days. Team investigation meeting and drafting. I went back and looked to try and see, a lot of these were like drafting. And at the time, I'm not sure what would have been drafted because most of this was during the special purpose grand jury. So there's not really a whole lot of drafting. We've obviously never seen anything that he specifically has drafted, but I also calculated these team investigation meetings. So the majority of the billing are things like meeting with team. So if you see here, it's got team investigation meeting. Then it's got team meeting and argument prep, and then meeting with team. Most of his billing is meeting with team meeting, team investigation, team brain drain. He called it different things like that. But I went through and that's the majority of the bill.
And this wouldn't be standard from what you see at block bill in 8-hour increments instead of, you said, 6-minute increments or
No.
more specifically, and does not really give a lot of identification of what's being done.
It gives pretty much zero, in my opinion, identification. This is not something that we would be able to submit to a client ever. I can't imagine. They would, if I billed them $2,000 for 8 hours of meeting with a team on one day, and just research without what I'm researching. You have to be detailed in your bills because that's accountability. That's the only way as lawyers we can be accountable. Our clients aren't sitting in our office while we're researching, so I have to say what I'm doing.
And somebody has to approve it.
Oh, yeah.
That's
And
right.
it's ultimately Fani Willis that was approving these either personally or through her designated assistants.
Yes.
And there was a written contract with Mr. Wade and the Fulton County DA's office?
There was, yes.
All right, let's see if we can pull that up, Senator Dolzall. Am I right that I think I've reviewed your documents, that there were more than one contract?
Yes, there were.
Is this the first one?
Yes, that's the first one.
All right, so that says it shall commence November 1st of 2021 and go through October 31st of 22.
Yes.
Okay, so that contract began before there was even authorization to have a special grand jury and later in November of 21?
Yes, it did.
Okay. Does it specify that that's what his role was going to be, or is there any way that's disclosed to the public, what he was doing?
No, up at the top, I believe it says, let's see, it just says attorney consultant. This one, so if you look under whereas, the first whereas, it says to provide legal services regarding anti-corruption matters. The head of the anti-corruption unit is a lady named Sonia Allen, and she was the one that was originally in the emails that I talked about earlier, negotiating immunity and things like that. So she's the head of that unit.
So the DA's office has their own special anti-corruption unit already in-house?
They do, and they have a director of that. Sonia Allen is the director, or chief assistant. She heads that unit, and she was the one that was originally on the emails negotiating immunity and things like that. And then it switched over to, there was some issue, I believe it was with Governor Kemp, on him testifying when, all of that stuff, and Mr. Wade took over and said, I'm the only one with authority. And so Ms. Allen sort of stopped working on the case, and she hasn't really worked on the case since.
From your experience and your knowledge of Mr. Wade and Sonia Allen, does he have any special unique experience or expertise that would make him better at this anti-corruption work than the head of the anti-corruption department in the Fulton DA's office?
No, but I mean, no, he would not. But Sonia Allen also hired Mr. Wade in Cobb County before this contract at, I think it was like $550 an hour or something, to investigate deaths in the Cobb County jail. So Sonia Allen was the chief. So when Neil Warren was the sheriff in Cobb County, Sonia Allen was the chief deputy. And so she basically ran the sheriff's office. They had a couple different deaths, and there were some lawsuits over access to that. A lot of the local lawyers wanted access to what was going on with the jail deaths. And Ms. Allen hired Nathan Wade to do that work, to do an investigation. And so a lot of this came out because they were ultimately sued. So I reviewed, part of what I did in this case was I reviewed all of those documents as well. Mr. Wade had to testify because one of the news organizations sued them and said that essentially Ms. Allen hired Mr. Wade to try to get around open records, to say that it was an open investigation so that they didn't have to give the jail recordings to the families.
So in other words, that Mr. Wade is good at what he's doing, but he is not qualified to do what they want him to do. Okay.
About how these inmates died. Mr. Wade was a witness and had to testify, and he had billed a lot of money, which I don't have the figure, but I've got the invoices, but he had billed quite a bit of money to Cobb County, but hadn't produced any documents. And so he had to testify, and his testimony was that everything was in his brain, that he didn't have any written documents from anything. But that's where.
That was some years before.
That was some years. I think it was in 2020, maybe.
So
it was right before
when
this.
did Miss Allen get hired by the Fulton DA's office?
Yeah.
When Miss Willis took office. So when Miss Willis took office was the same time that Mr. Warren, who was Miss Allen's boss, was no longer the sheriff in Cobb County. So a new sheriff was elected, Craig Owens, and so he was elected in Cobb County. He took over that office. Miss Allen no longer had a job, and she was hired by Miss Willis to head the anti-corruption unit.
Okay. So, from your documents you've produced and your news stories that I've read, apparently there were other special counsel that were hired by Miss Willis?
Yes.
And to work on these specific RICO cases or election fraud cases?
Yes, so there's several, and so that's kind of a longer answer because there's a couple different classifications. Mr. Wade was, at the time that he got this contract, he was law partners with a gentleman named Terrence Bradley and another gentleman named Chris Campbell. So it was a three lawyer firm. Both Mr. Wade and Mr. Campbell had contracts also. They actually had contracts before Mr. Wade. So they both got contracts the month that Miss Willis took office. They got contracts to do what's called taint work, which is essentially if, for anti-corruption, because it's a lot of police brutality cases, if there's things that could be considered privileged. So let's say the police union had a lawyer doing an investigation, they subpoenaed those records, those are privileged. Somebody has to review those to see what the DA's office can actually see. So it's that wall, that privilege wall sort of. So both of Mr. Wade's law partners had contracts to do that privilege review, that taint review, conflict review.
So you're seeing if there's tainted evidence, something that should not be revealed might damage another case, or it might be privileged and not subject to disclosure.
Right, exactly. And one of the best examples I could give is, in the Tex MacGyver case, he was a lawyer. They seized a lot of his documents. A lot of them were attorney-client privilege related to other people. The DA's office was not able to just go through all of those, so they had to have a taint team, is what they call it. And so that taint team, and I don't know which cases, but the taint team involved Mr. Bradley and Mr. Campbell, who are Mr. Wade's law partners.
Basically, they're reviewing documents to see whether they should be produced or privileged by attorney-client privilege or something else.
Exactly.
Not exactly prosecuting criminal cases then.
No, they weren't prosecuting criminal cases. But Mr. Wade testified that they were law partners at the time, so that he would have shared a third of whatever contracts they got. So those contracts, he was getting paid essentially from the law firm as well.
Right. So on this case, these RICO cases that you're involved in, one of them, there are other special counsel in addition to Mr. Wade?
Yes, so there's two other, on this case particularly, there's a lady named Anna Cross and a gentleman named John Floyd. And John Floyd has worked with the DA's office for many years. I actually was involved in another RICO case year before this one, which luckily my client resolved his case, so I'm no longer involved in. But that case, John Floyd had also helped craft the indictment. And, he's sort of known as a go-to person for racketeering cases, so the district attorney would regularly call on him to help in drafting indictment. Anytime we would file what's called a demurrer, which is a motion to quash an indictment, he would usually be the one that came and argued it. And then Anna Cross was also hired, and she really focused on the work in federal court. And both of those sort of make sense to me because Fulton County prosecutors they're not necessarily barred in federal court. It's not something that would be required for your job. When I was a public defender in Fulton County, I wasn't barred in federal court. I had no need to. I wouldn't have paid the dues, wouldn't have done that. So it's not something that would be required for their job, but Ms. Cross is experienced in that. So she was hired sort of as a subject matter expert to litigate some of the federal removal issues in this case.
Did those two individuals have contracts with the DA's office as well?
They have had contracts historically. They do not currently have contracts. It's very odd.
Did you review their billings?
I did. I reviewed their billings. Stark contrast. So Mr. Floyd, for example, he was only paid at a rate of $150 an hour. And
Same case.
Same case. And he
More
is,
experience and expertise in RICO cases.
I mean, everybody would agree. I think that John Floyd is one of the preeminent experts on RICO. I believe he testified in front of the Georgia legislature when RICO was passed.
Did he have to submit itemized invoices?
He did, and his were very different. His were significantly reduced, and the big difference was he billed for the time that he was working on the case, not necessarily like 8 hours for team meetings and
Did he
things
have
like
itemized billings?
Very much so.
And what increments did he bill in?
I might have some of his contracts with me, but it was either 10 or 15 minute increments. And so did Anna Cross. Now, Anna Cross was paid $250 an hour. Anna Cross is very well-known, very experienced appellate, federal lawyer, does a lot of complex litigation. She was a DA for many years, handled a lot of high-profile cases for the district attorney's office. I mean, I know her back from when, we did death penalty work in Cobb County together 15 years ago. And then she went to DeKalb County and prosecuted a number of high-profile cases there. But just very well known, and her bills were also submitted, but they were the same rate. They were $250 an hour, but they were much lower bills, not anywhere near the bills that Mr. Wade did.
Do you know how much Anna Cross has received during the course of this criminal prosecutions or
I'm not sure.
investigations?
I might. Let's see.
Okay. You said Mr. Wade had about $700,000 so far?
Yeah. Miss Cross was under $100,000, I believe.
All right. So if she's under $100,000, what about Mr. Floyd?
Mr. Floyd, much lower, even lower than Anna Cross.
How much?
He has not billed in a while, so I did subpoena, but I also did open records for all of his bills. We've not been provided anything recently from him, so I'm not sure if he actually did bill, because his contract said you have to submit the bill within a certain amount of time. So I'm not really sure. They stopped responding to my open records requests, but when they did respond, they were very, very limited, very small bills.
And your open records request was to whom? The Fulton County government, commission, or the DA's office?
I did them to all of them, and once especially that they stopped responding to them. So they have a portal And it's, if you go to the DA's office and you click open records, it takes you to the Fulton County portal. So if you try to submit it to the DA's office, it necessarily goes to a portal for the entire county. So you have to submit it through those. So that's where I would submit it. You can designate, I think this is the DA, I think this is budget, things like that. So I would be over-inclusive just to make sure that I wasn't missing somebody. But every single time they would route it to the DA's office. So I would get a response that said it's been routed to the DA's office and, we're waiting on the response. There were one or two that I got from the county that didn't appear to be routed to the DA's office.
And so who's refusing to produce these records to you?
The letter came from Dexter Bonds at the DA's office.
And
Dexter
that's
Bond.
why you filed a lawsuit against the DA's office to force them to comply with open records?
Yes.
Okay, that's still pending?
It is still pending.
Fulton County Superior Court?
It's Fulton County Superior Court. It's assigned to Judge Krause, I believe, and the county attorney contacted us and says they're going to be responding. So the county attorney is actually defending that lawsuit.
Right. And so they're telling you they're going to respond to the case or respond to the request now? You're waiting to see?
I believe the case. I haven't received any documents, so.
Fairly recent filing you filed there, that lawsuit?
Yeah, so we filed it in January, and then they had a little shutdown in Fulton County where nothing was able to be file stamped. Our process server couldn't serve it until it was file stamped, and the Odyssey, the e-file system in Fulton County was hacked, and so it was shut down for a while. So it took us a little bit of time to get a file stamp copy back, but it's now been served. But it was filed on January 30th.
Of 2024.
2024, and I have a copy, which
I don't have that. If you would provide us with
Happy
that,
to.
then we'll give it to the Secretary of the Senate as a supplemental response to the subpoena.
I'm happy to. This is a clean copy.
Okay.
Yes, so you all can.
So what's the relevance
this.
to you? Why did you seek these billing records of these attorneys?
I wanted to compare the different billing, the different styles of billing. Also, there had been an allegation that I was singling out Mr. Wade, and so I thought it was relevant to see the rates that the other attorneys were paid, their billing, what type of billing, if they billed for everything. Just for example, when we're in court, one of the prosecutors may be arguing, Mr. Floyd and Ms. Cross aren't there billing, but Mr. Wade is always there. So that was one thing that I noticed, and I understand now that their response is that he sort of is like a case manager almost, so I guess that would be why he's always there, but I wanted to compare them and see.
Okay.
Ooh, child. She all in there.
I want to show a couple of things. Senator Dolezal, I want to show some of the other billing records, particularly ones that showed the trips to D.C. We hadn't had but a couple of days to review all your documents, and I skimmed these records because I wanted to know exactly what was going on. You'll see highlighted down here at the bottom on November 18th of 22, interview with D.C. White House, 8 hours. Do you know what that references?
Based on another motion that was filed and the arguments that were made by the DA's office, I believe that was when they met with the Department of Justice. They met with the January 6th committee. So one of the co-defendants filed a motion to try and get some documents, and the state had to respond. It was a motion to compel. I was there for it. I joined it, but I didn't litigate it. And the state said that they had to meet off campus. So because they didn't have a record of it, I guess you have to have a record if you go into the White House. And so they met with the January 6th committee off campus, and they said they had a really hard time getting that meeting, and they had to have someone who had some source or something to get them to agree to the meeting. But that's what, so the motion to compel was based on this entry, and this entry in response, they said they were meeting with the DOJ and someone with January 6th.
There's also an entry, May 23rd, 22, travel to Athens conference with, what is that, White House?
Yes, and we've tried to figure out who that was, because there was something happening at UGA Law School, and so we just assumed that it was someone.
What I'm gonna do, y'all, I'm gonna skip it a little bit, okay? Right, I'm gonna put it back right in here.
Book in when she was deciding how to prosecute this case, who to indict, who not to indict. I mean, their whole thing is that they had unfettered, behind the scenes access to her thought process and stuff. So, and she's talking about all of this, that they're guilty. But the big thing for the forensic misconduct is she's in the church speech, she's saying, and she says this in the book too, that God has told her to prosecute them. So between these two things is that God told her to do this, and that she is doing the will of God by prosecuting our clients. And that is...
That's unethical.
In my opinion.
All right, so there was, I'm trying to recollect what I remember reading in basically the Atlanta newspapers about all this, because this was new to the state Senate as well, because all of this began on January 8th, which was that the day we started, 8th or 10th or something?
It did, and
it was the day session began, and all of a sudden these bombshell allegations come out, and I think that was the motivation for our Senate resolution forming this investigative committee to say, let's find out if this is true, independently of all you guys' legal issues or whatnot. So I remember she wouldn't testify in the divorce case.
Right.
But did you subpoena her to testify in your motion to disqualify?
Yes, and she filed a motion to quash.
She refused to testify, but then she came to court and did testify.
Yes.
Okay. And in that...
As they were arguing the motion to quash.
I wonder, okay, so in that testimony, did she deny the start date of this affair?
Yes, she said it started in early of 2022. There was some discrepancy between them, a month or two here and there, whether it started, generally it was around March, is what Mr. Wade and Ms.
What are the
Rose.
consequences for an attorney to give sworn testimony that she did if you're Bradley, what is it, Yearty, your Trackhawk data, your other independent verifications are found to be truthful?
It's a crime. It's a felony. You'd lose your license.
Okay.
It's perjury.
Same for Wade.
Yes. And we have rules that are one of the, outside of privilege and confidentiality, we cannot suborn perjury. So if I have a client who tells me I did it, I can't put them on the stand to say I didn't do it.
Okay.
I would lose my license over that. I cannot do that.
And Yearty came to court and said, oh yeah, this started in 2019.
She saw them, she saw them together. She testified that she saw them romantically together. And they were very close.
Okay. And you had Bradley's text message that showed he confirmed that absolutely back in January.
Yes, and he had a lot of details, little details that matched up.
Did you get other details from him by phone?
Yes.
That wasn't in the text? What did he?
A garage door opener that Mr. Wade had a garage door opener, and then I subsequently learned that he told Mr. Aurora the same thing.
Garage door opener to her place?
To her place.
Okay.
Mm-hmm. Yeah, to her place.
So,
there were other things, just a lot of context, things about how freely Mr. Wade could go in and out of the office, the DA's office, stuff about that they would sometimes use hotels. One thing that he told me was that Mr. Wade had, before he filed for divorce, had used Mr. Bradley's credit card and then paid him back in cash for, so that there wouldn't be a record.
Well, that's a good friend. She trusts him.
I'm a little puzzled by the legal standard.
Me too.
I'm reading the newspaper articles that explain to us the difference between a conflict of interest and an appearance of a conflict or an appearance of impropriety.
That is the big argument right now. And I'm not the best person to explain that. My husband argued that part. But, appearance of impropriety is one of those things like that if it undermines the outcome, undermines the confidence in the outcome. And we spent a lot of time in our brief talking about the constitutional underpinnings of this. Due process, that my client has a right to due process. He has a right to a fair and impartial prosecutor, and we don't think that's happened in this case. And so I think that would be more along the lines of the appearance of impropriety, and then actual impropriety is receiving money, like receiving money and not paying it back. And there was testimony about that. Ms. Willis
Well,
came
he
in
said
and
she
testified
said
that
he
Mr.
paid
Reagan-
the money.
that
They
she
paid the money
paid it
back.
in these sums of cash, but there's no records of any of that or where she got it.
Anything shows him depositing cash or
No,
receiving cash?
no, and we asked her like where you got it. She said that she said she borrowed it from her campaign. So, she said the original large sum of cash came from her campaign.
I
She
think
took
all
that
of
out.
us up here that have campaigns know you can't take campaign funds for personal use, right?
I'm not well versed in that area of law, but that is my
It's
understanding.
pretty black and white.
So she testified that she took that the majority of the cash she had on hand was from her campaign, that a loan she had given herself from the campaign. She was very clear about that. And then she also said that when it got low, she would supplement it by getting like $50 back at Publix. But I mean, she's giving him, $4,000, $2,500, so, large sums of cash. So, and there's no trail, obviously. There's no record of any of that.
In some of the documents you produced to us, there were a couple of IOLTA trust accounts. Those were Mr. Wade's accounts?
Yes,
Okay, so he had more than one trust account in his law firm?
yes, he did.
And did you find any discrepancy or whether these funds were deposited there?
Yes, and, so he testified because we asked him where he deposited the funds.
And these are the funds where his paychecks basically from Fulton DA's office?
Yes.
Okay.
At first, he deposited them to his joint IOLTA that he had with his law partners, and then he started depositing them to his when I say personal, just him IOLTA, an IOLTA that did not have anything to do with Mr. Bradley or Mr. Campbell.
Do you think Mr. Bradley was aware that he was running the money through a separate account,
I think it might have been part of the reason that they dissolved.
that they broke up?
Yes.
Do you think his ex-wife knew that this money was being held in a trust account rather than previously it had been going through his home bank account?
His ex-wife didn't have any idea. I mean, you could tell from the pleadings that he was even making this much money. I mean, he filed some interrogatories and some answers in that divorce case saying that he made a couple $1,000s a month. I mean, very, very minimal amounts.
Well, we knew he was making up to $35,000 a month under this contract.
Right, and he has a lot of money parked in one of those IOLTAs that's not disclosed in the divorce.
Okay. So that's, does it look like he was using his law firm trust account or his personal lawyer? IOLTA is a legal trust account, right?
Yes,
The interest from it goes to the state bar to help fund some
Yes.
indigent care or whatever, right?
Yes. As much as I wish we could park money in our IOLTAs that was earned and not pay ourselves, we can't do that. So when you earn money, you can't leave it in your IOLTA. IOLTAs are for client money, so they're a lawyer trust account, and essentially what they are is like if you settle a divorce case, not a divorce case, I'm sorry, you settle a civil rights case or a
Personal injury case.
personal injury case, and you get $100,000, and 60 of that's the clients and 40 of it's the lawyers. It has to go into your IOLTA. It sits there until you clear the case out. You've settled, you finalize the case, you send a settlement letter, you get the amount, and you have to put it in your actual business account, and then the client gets their check for their part. So IOLTAs are very highly regulated by the state bar. They can't commingle funds. It can't be earned money. It's got to be money that's not earned. And the interest does go to the state bar, but once you earn the money, you have to pay it. You have to have it in your account because you have to claim it on your taxes.
Right.
I mean, lawyers wish that they could keep money in IOLTAs and not have to pay taxes on it until it was a year that,
All right. So
Financially,
sometimes
they wanted to.
attorneys may take a retainer up
Yes.
front and bill against that retainer. Say, you might do that on some of your criminal cases. So, yeah,
Yes.
I'm gonna take $25,000, I'm gonna put it in my trust, and then I'll submit an itemized statement and pay myself as I earn the money.
that's exactly what they do with retainers, with retainers that are refundable. So they would ask, $10,000 retainer, and then if this month I billed $1,500, I send you a bill, and then I take the $1,500 and I transfer it to my business account.
Okay.
As soon as it's earned, you have to transfer it.
So these funds, if they in fact came from the contract with Fulton County, should probably never been put in a trust account at all because they were already earned after he had done the work, and within some amount of time after that he sent the bill and he got paid for work that had already been done.
I mean, if they were put in a trust account, they would need to be transferred quickly.
Is that the kind of
I don't do that, but
ethical violation that can get you disbarred?
they highly regulate the IOLTAs, highly regulate. I mean, the state bar like, there's a list of places that we can do banking because they're regulated by the state bar. I have to go in person for most of my IOLTA transfers. They're not something that I can do like online banking. I mean, it's a pain. Okay. But yeah, so they're highly regulated, and we know these were deposited in his IOLTAs because the back of the checks for Fulton County show where they were deposited.
And have you asked him about this? Has he given any explanation for why he ran this money through a trust account, or is it still in there? We don't.
I mean, the last I knew, he didn't give any explanation. I mean, he just said that he pays for everything through his business, and then he basically just said his accountant figures it all out.
Okay. I know you have a court appearance this afternoon, and you've been very patient with us. I'm going to give Senator Harold Jones an opportunity to ask a few questions. Under our rules, we do allow at least one member of the minority party to participate. And Senator Jones, you're not time limited. If you, when the buzzer hits and you've got to go to court, you tell us, but I feel like we got at least 15, 20 minutes.
Oh, you definitely do, and I'm happy to answer any questions you have. My court's at 115 in Fulton County, so, if I get in trouble, if you can call the judge, then I'm fine.
You got it.
I just wanted to go back to the issue about the conflict, because I think that's kind of what brought us all here to some extent. On one issue, in your brief, the most recent one that you filed.
The second one?
Right.
Okay.
On page 21 of that, you went ahead and acknowledged that the aspect about him not signing, I believe, or being duly authorized to be a prosecutor, that's already been handled in one court, but you're still bringing that issue back up. But it has been decided in the negative. In one court, of course, you are still bringing that issue back up.
Yeah, so you're talking about the oath?
Right.
The oath issue. Yeah, so Manny Aurora was working on this issue early on, and he filed a motion about the oath. At the time, it hadn't been filed. And in and of itself, that's not, that's not filing an oath. That's not going to get rid of a case. That's not going to disqualify in and of itself. Clearly, the judge told us that in an order. But I was trying to paint the entire picture and how I felt that it was relevant. And it definitely is not a ground that I was arguing for disqualification, but I felt that it was relevant because it shows that they were hiding this relationship, and all the evidence indicates that.
Right, and I was just kind of showing why I'm moving on to this next particular point here, which goes to page 24 of your brief, which deals with, I think, the thing that's really out there in the media, which deals with the relationship and aspects of that in some kind of way this creates a conflict of interest. And, of course, the judge is going to rule on that, but I still think it's important to kind of go through it. And you cite the case of Whitworth versus State. What in that case actually applies to this particular case?
I don't know if I'm looking. You said it was the last one that I filed?
Yeah.
So February 9th.
Yes, page 24.
Page 24. You said Woodward?
Whitworth.
I don't see Whitworth.
At the bottom, Georgia courts have developed their own standard for disqualification of prosecutors.
That's not my page 24. You must be looking at a different, the one that was filed February 9th at 3:47.
We can't hear you.
I'm so sorry. I'm so sorry.
The microphone just flew in closer to you.
Yes, I want to make sure I'm following the same one. You're talking about the defendant supplemental reply that was filed on February 9th at 3:47?
No, let's go back.
Okay.
Let's use your first one.
Okay.
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 Yeah. One that's a little bit more. Okay. So that one there on the Whitworth case. Tell me how that actually impacts this particular case.
Which page are you referring to?
Page 24.
Page 24. So the site is Whitworth. The court recognized a conflict of interest as a ground for disqualification. Held to arise where the prosecutor had acquired a personal interest or stake in the defendant's conviction. And I don't, I wish I had that case in front of me. I don't have the case in front of me, but essentially, to answer your question, that first of all is physical precedent only. So
right.
Yes, and we
But you did cite it.
And said that it's physical precedent only.
And you're using that as the basis, really, to say it's a conflict. There's no other case law that you actually use in this particular brief to say it's a conflict other than Whitworth, and also amusement sales, which deals with contingency fee.
Right.
And so in Whitworth, and I have the case if you want to go through it, it actually talks about that there's ways of citing the conflict.
Right.
Number one would be if he had or prosecutor had actually spoken to the defendant. Has that taken place?
No.
Okay. Second, has he represented the defendant?
No, he hasn't. There was a motion early on. I didn't even bring this up here, and I don't think we talked about it in the brief, but there was a motion early on because Mr. Campbell, who's Mr. Wade's law partner, actually sent a mailer out to my client and all of the other defendants. That. Yeah. So I don't think anybody called based on that, but they did advertise to them saying, call us to represent you.
And then they came with the third, which says there has to be a personal stake in the defendant's conviction.
Right.
So is that what you're relying on there, that there's a personal stake in his conviction?
No, in the prosecution also. So, and in that case, that's physical presence only, and I don't remember the specific facts of that case, but it's not just a conviction. And obviously, the state wants it to be just a conviction, and we argued this extensively over 3 hours, I think, in front of the court, but it's also a personal stake in the prosecution, and that was an amusement. Prosecution in that case, that was a contingency fee case. So
that's
that was
correct.
Completely different. Yeah.
And so in amusement, it was a contingency fee case. So they had a personal stake, actually really in the conviction, because they only received the contingency fee when the conviction happened.
Right.
So what you're really saying is that they had a personal stake in just bringing the case, because he can't have there's no personal stake in the conviction similar to amusement, correct?
Well, so amusement's a little bit different because there is no conviction in a forfeiture action.
Correct, but they're going to get money if they win.
Right, but there's no conviction.
But they're going to get money if they win. That's the key.
They get money if they keep the forfeiture. So it's where that was a forfeiture case. I think that was like game slots.
That's correct.
Yes.
But they get money if they win.
Right. But
that's the only way they get money.
Yes.
But they don't get money for bringing it.
So I just wanted to make sure it was clear
that
that was not conviction, because you can't have a conviction.
But they only get money if they're the victor. He's receiving his funds. Mr. Wade is receiving his funds because he's billing because the case is going on, correct?
Oh, yes.
Not because he wins a case.
No, he can lose the case and still make a ton of money off of it.
So what you're saying is the actual conflict is just bringing it.
No, the actual conflict is, that's a long answer. The actual conflict is lying on your disclosures about how much money
I'm talking as far as this issue is concerned right here. When you use with worth, you use amusement sales, and they say that there has to be an actual conflict. And amusement sales, and let's go back to Whitworth if we can, because in Whitworth, the person was actually told, the prosecutor was actually told by another prosecutor that they want the case to actually resolve in a conviction. Because what had happened was the defense attorney came to the prosecutor and said, we would like to plead. And the prosecutor basically said, no. He went and got advice from somebody, and that prosecutor said, we would like this case to resolve in a conviction.
Right.
And so the question, and that then was held not to be a conflict. They said that still is not an actual conflict, even though someone told that prosecutor. We want to see a conviction. We actually want to see it go to the end. Don't plea him out. And the court said, no, that's not an actual conflict, because what you have to show is there's an actual unfairness to the defendant in the trial.
Right.
Can you point to any unfairness in the trial that's taken place?
It's not in the trial, so it's not limited just to the trial. But to answer the first part of your question, when you were asking about the conviction of personal mistake, Ms. Willis has made numerous public statements about her interest in a conviction. There's some emails that had been admitted as part of it, as part of some of the exhibits in the case. There's a lot of pleadings, so I don't know which one exactly, but talking about her desire for there to be a conviction and jail time. And then in my case, for example, so Mr. Wade offered my client misdemeanor probation. So we were the first people to get an offer. And we said no, we wanted a dismissal because he was not guilty. And that did not happen. So obviously there's an interest in him being convicted of something, because when the plea offer was for him to pay a $5,000 fine and have a misdemeanor.
So in reality, because you said that he wanted to extend the case out, he was actually trying to end your client's case.
With a $5,000.
But it was going to end. It would be no more billing on that case, because earlier you said that you believe, which was total speculation, that they created this case against your client to do more billing. And what you're just telling me now is that he was willing to stop his billing because he offered your client a misdemeanor and you rejected it. You're the one who's continuing the billing.
I don't bill by the hour.
No, you're the one that's continuing to make him bill. He was willing to cut that off. You said, I believe that they created this case against my client so they can continue to bill. Well, he basically went out and said, I'm tired of billing. I'm going to offer a misdemeanor.
Okay,
And you said no.
take a couple notes because you had a couple questions there. I want to make sure I answer all of them. So the billing, so as far as the billing and the offer. So what I was trying to explain, and I'm glad you gave me this opportunity to sort of go into it in a little more detail. I tried to explain that there are really three classifications is how I broke the indictment down. There's the folks that are involved at the federal level. You see those people having, they were in DC. Then you see the electors. Then you see coffee. These cases could have been
Ms.
handled.
Merchant, we can't even hear you.
Oh, I'm so sorry.
Just pull
I
it
didn't-
up right
sorry.
to you.
He
Pull
told you to
the
put
edge
it
of the desk
close
if
to
you have
you.
so everybody
Okay,
can hear.
sorry. Okay,
Jesus.
so how I was trying to explain it is I separate this down into three different types of cases. And it could have been handled that way. Coffee County could have been prosecuted in Coffee County if it had been chosen to do that. The stuff with the federal could have been handled in federal court if they had chosen to do that. Then the electors would have been the only remaining case that could have been prosecuted in Fulton County. Instead of choosing to do that, and it's not just my client in particular, but that group in the middle, by putting them all three together, it expands the litigation. How it expands it is a couple different ways. It expands it because when you charge a RICO case, you can bring in evidence of everything. So essentially, instead of having a case, a quick case, a case where there's evidence against Michael Roman, only Michael Roman, we litigate that. They expanded it to include these three different classifications. What does that do? That means the trial is going to be a year. They can plead people out. They can plead Michael Roman out. They can plead this person out. They can plead people out, but they're always going to have that large enterprise. And it actually does, even if they pled my client out, the offer was for him to testify. So, for him to testify, even though he would not be on trial, his acts would still allegedly be on trial, which still expands the litigation because he's not gone. The deal's not, you plead out and you're gone.
Excuse me.
Bye. We're not taking up time with you. It still expands it. So my whole point earlier was that this expands the litigation because imagine if we just had, like you see in other cases, one defendant. You can limit the information to just that crime and that case. Or you could have three separate indictments. But what we've done here is we've put them all together. You've made it so that it's necessary to have three trials because there's no courtroom that can fit all of those people. So that expands the litigation.
So in the case that you cited, physical or not,
Which one? Whitworth?
Whitworth, it says specifically that when the prosecutor goes up, Morgan, who is the person who was talking to him, who's the prosecutor, Hobbs informs Morgan, who is the prosecutor, that he anticipated the successful criminal prosecution, but that any decision regarding Whitworth's proposal to Morgan was Morgan's to make. Morgan decided to continue to go forward. And they said that was not a conflict, that was the prosecutor's decision to make. And you're saying, this is the case you cite. Well, in your case, they actually came to you and said, we're willing to give you a plea. And you said no, which is perfectly fine. But then you say, well, they want to extend prosecution on my client. They were willing to cut it off. And so therefore, the case that you cite is totally opposite than what the situation that you're dealing with. How would you say that you have a conflict in this case? Based on this case, just based on this case. That was your first case that you cited in your brief.
I don't think it was actually the first case, but
The first Georgia case you cited was Whitworth on this particular issue.
Right, on a particular issue.
Correct.
And again, I don't have Whitworth in front of me, and there's a lot of different facts about these cases. I would be happy to review it and let you know. But what I can tell you is that I still, and we still believe that this is to expand the litigation. And even if it's minor, the law says over $100, that's enough to have a personal interest. So what we've got these financial disclosures where they're not being truthful. Ms. Willis is lying under oath, which is the same thing my client is charged with conspiring to do, lying under oath about receiving a benefit over $100. So you've got those. You've got this concerted effort, which seen unfortunately drag out over the last couple months, this concerted effort to hide this information from the public, to keep this information out. I think that it is very reasonable for a court to think that that is a conflict of interest. And whether or not it's a stake in the conviction, a stake in the prosecution, we definitely have seen a stake in the prosecution. And Whitworth, the problem with Whitworth, and this is...
Who actually brings the case?
The district attorney. Well,
How do they get the case?
well, we know a lot more now because of the book Find Me the Votes. So we know a lot more than we normally would
So how
know.
do they get the
So,
case?
and that's one of the things that I talk about in my motion. In this case, it was actually Nathan Waite. So he's the one that he presented most of the witnesses,
How is your client charged? How are these clients charged?
My client was charged just in the actual grand jury.
Okay,
Yeah.
so grand jury.
Yes.
Okay, so we had a special grand jury, and then you had a grand jury
Yes.
who made this determination.
Well, yes.
They made a determination to bring charges, basically, to indict, correct?
Yes, and I.
So are they part of all of this?
No. But I've never had the privilege of being inside of a grand jury, but I have heard a lot about what happens inside of a grand jury. It is a witness who comes, and in this case, it was actually the investigator for the DA's office. So just understand this, it is a very low standard of proof. It's probable cause. I have had clients who were dead indicted. I actually had a lawyer that I worked with at the public defender that was indicted along with his client because the DA presented an indictment that actually had the lawyer's name on it by accident. And the grand jury indicted him.
So you're saying the grand jury has flaws?
100%.
Oh, so would you think it'd be better for just the prosecutor to draw the accusations?
No.
So the grand jury,
I know you guys have a bill doing that right now. No, I definitely don't think so. The grand jury is better than no oversight.
correct.
Definitely, but
Right.
it's a continuum. So my point in bringing that up is the grand jury is not perfect. The grand jury is. I'm not allowed to be part of the grand jury. It is not what I would call adversarial. So the grand jury is one-sided. They only hear from the prosecutor. So, and they hear hearsay. So in this case, using it as an example, the investigator for the DA's office listened to all the January 6th testimony, read all the testimony, went in there and summed it up for the grand jury. They present, the grand jury doesn't draw up the indictment. They actually, the prosecutor brings that indictment, and then they vote, and it's a majority. So all they have to do is a majority vote, and it's by a very low standard. It's a probable cause, which is about 25% proof. So you've got hearsay, you've got a witness who hasn't actually witnessed anything personally, you've got a standard of 25%. I think there should be much more safeguards on the grand jury process personally, but that's for another day.
So you went through special grand jury and they made their
That's right.
recommendations. Then went to a grand jury and they, of course, made their recommendations. And how many persons have actually pled in this particular case?
2 or 3.
2 or 3 already.
And they were well, there was one, so the first gentleman who pled, he was a bondsman, and he was not, because of the state law for bonding agents, he's not able to actually run his business while he's on bond. So he had a significant financial interest in entering a plea early on because he was essentially couldn't work if he didn't enter a plea. And I mean, he got probation. You know, it was not what you would imagine in a huge racketeering case. You would not imagine probation and a $5,000 fine. The other 2 people who pled are both lawyers at the end of their career, and you know, I can imagine when I'm close to retirement and I have my retirement funds, if I would want to spend them on a criminal trial or spend them seeing my grandchildren, I would spend them seeing my grandchildren.
One of the things we've been talking about is Mr. Wade's kind of qualifications. So, but you did mention early on that he was very instrumental in the special grand jury process. So he's been there. He's been part of this process.
Oh, you can see that by his bills, yes.
Right. So other than just his bills, you said that you recognize that he's been part of the process. So even though he's very, I guess, what everyone's saying is inexperienced, he was able to go to a special grand jury and get their positive recommendations, I guess, from state side. He's able to go to a grand jury and get indictments, which positive for the state side. And he's actually had some persons actually plead guilty. So this inexperienced former assistant solicitor, I mean, he's not doing too bad, is he?
That would be up for dispute. I mean, if you want to talk about his qualifications and whether I think he's qualified, I'm happy to talk about
No,
that.
I'm just saying, I mean, when you say that someone's totally unqualified, that's basically what's been going on. It's very surprising he was able to go to a special grand jury. You say he's integral in
that's
that.
not surprising at all.
And he's going to a grand jury, you say he's integral in that.
Yeah.
Then why even say that he's inexperienced and he's getting people to plead guilty? But basically you're saying those are just lawyers that don't want to do anything anymore. They just pled their clients guilty.
No.
I understand.
No. So the special purpose grand jury, first of all, remember my client was not recommended as far as that.
I understand.
The special purpose grand jury, I've had the opportunity to read a lot of the transcripts from that. It's direct examination. So you're bringing a witness in and you're talking and you're saying, tell me what happened. So did that along with Mr. Wooten, and he never did it all by himself. He definitely led it, but Mr. Wooten asked a lot of questions, and there were some other prosecutors in and out, but he was always there. But that, I mean, special purpose grand jury is really just to investigate and get testimony.
I understand.
So it's not.
But when a person's trying to insinuate that somebody's basically totally unqualified, it is important to realize that they've walked this case to this particular point. Very complicated case, I'd imagine.
I mean, that's something that we could debate. You know, if walking someone through the grand jury, the special purpose grand jury is complicated
Special
or
grand jury.
not. You know, asking questions, and again, there's a team of 10 lawyers. So
that's a team of 10 lawyers.
who knows what part he's doing? But the question would be then, why him? Why not all of the public servants who are taking government salaries and, you know, restricted in their private law practice? Why do they need him there when there's all these other people? As far as the qualifications, asking questions in a special purpose grand jury in and of itself, I mean, there's no opponent, there's no adversary, there's no judge.
Once it became adversarial, you've had persons start
And-
pleading. And maybe more potentially, correct? Possibly. But we'll find out. But let me ask you this, though, because you were talking about the staff. One of the reasons you may go outside to outside counsel could be the fact that if you actually put this type of case within the office, just speculating, but to some extent we all are, the office would basically shut down. It's a potential that the DA's office would actually basically shut down.
Oh, God, no. If you took the $1 million that he's been paid, you could hire 5 lawyers.
You could do that, but how long would you be able to keep them? In other words, if you hired 5 new inexperienced ADAs, they're not tackling this case. And also,
Well, the inexperienced ADAs are not going to make
He's going to-
$100,000. So if you're hiring inexperienced ADAs, you'd probably be able to hire 20. But that's not what.
But the key thing is, that job that you're talking about that you're going to hire with that, with the $1 million that you'd have paid him,
Yeah.
if that's your theory on it, that's not going to stay. That's not necessarily going to be long term if you're just saying the money you paid him, you could have done this. Because his is a short term kind of situation. His is on contract, so it's short term. It's not a long term contract. It's not going to last for a person's career. So
Right.
I understand the back and forth when persons were saying, well, they could have used this money for that. But that money was delegated for him on the short term project, so to speak. So it's not anything that a person would come in long term and actually necessarily do. But at the same time, that would be up to the district attorney to make that decision, how she's doing that. I just make the point that so far, from a district attorney standpoint, I would say that they probably believe that so far the case is successful. And we can argue about what's qualified and what's not, but certainly I think that they would argue at this point the case has gone from a successful pattern for somebody that's been denigrated and said is totally unqualified. I did want to go into these trips. How much was the money? Go ahead. Thank you.
Was that a question? Because I'd like to respond if it is.
Yes.
Okay. I took notes because there were a couple different questions in there. So the first one, you said about how much money. So Ms. Willis had stated that it would be between $3 or $4 million to actually pay Mr. Wade completely to prosecute this case. So you'd be able to hire a number of prosecutors. Some of them do come and go, but most of the prosecutors we've seen on this case have been there since the beginning. So, you know, unfortunately, these cases take time, so people may leave. You also asked me about that this money was delegated for this, and I just wanted to make sure that my testimony was accurate. This money was never delegated for this. The county did not ever delegate this. The county was not involved in that at all. Ms. Willis is the one that decided, and there's no budget. There's no transparency at all on this.
She does the contract with him, and I believe you showed those contracts. So in that sense, it's delegated to him because that contract can end at any time. She could say, "Hey, the contract because he works at her pleasure."
Oh, yes.
So that contract can actually end at any time. That would be the point.
Yes.
On the trips, how much total were the trips?
About $20,000.
And I think it was about 17,059. But even if we say 20,000, what was the average cost of each one of those trips?
Well, unfortunately, they did not provide all of the records, so I can't tell you exactly. All I can tell you is what Mr. Wade charged on his credit cards. I can't tell you. Most of it was paid in cash, so there's no record. So I wish I could tell you, but
going by your slide, one was 3,335, one was 4,453.
Which one? Hold on, I want to make sure I'm clear on each.
You had 6 trips.
Okay, but which trip are you talking? Well, you said one is 3,000 something. I want to make sure I'm clear.
Yeah, put it back up for me, please.
Yeah.
There we go.
Okay.
So the first one, Royal Caribbean, 3,335. Aruba, 4,453. And then you see the next one, and then the next two. How would that compare? I mean, what is that so unusual for on price points as far as trips are concerned?
No, I mean, I don't think so. The Royal Caribbean, so I can tell you because I know these records really well. I mean, Royal Caribbean, I specifically kept out the money that he spent on his mom's cabin. So they had two cabins. His mom had a cabin. They had an oceanfront balcony. For Bahamas, I think oceanfront balcony is probably upper middle, but I don't know that it matters. Flew comfort class, not unnormal for a lawyer.
You know what maybe the average American spends on a vacation?
Not this much.
You don't think?
No.
Have you looked?
No, I haven't, but I would imagine most of the Fulton County taxpayers would love to go on any of these trips.
Well, if you, since you speculate a lot, I could speculate and say that you did look, and that's why you didn't put it in your brief.
I did
Because
not.
Forbes actually says that the average is about $3,700 that a person spends on a vacation.
For a single person or a family?
Family of four. Well, at that time, they were taking 2 and 3 at the time.
That makes
so
sense.
That makes
So
that's about
no,
normal.
hold on. I want to make sure that's clear. You said they were taking 2 or 3 at a time. All of these, I made very certain that my numbers only included the 2 of them. So the one trip that they took
But
his
it's
mother on,
2 adults.
2 adults, yes.
It's nothing extraordinary.
So you said $3,700 for a family of 4. That does not surprise me. For families that can afford to go on vacations, does not surprise me.
So it's basically what the average American would do.
So this
Yes.
is half of that for 2 people. So you said $3,700 for a family of 4. This is for 2 people,
Right. It's just 2 people.
right? So
Yes.
That's still not enough money to
So
me.
it wouldn't necessarily be half. It's 2 adults. Bottom line is, it's not extravagant. It's not lavish, is it?
The law only says $100. So
But it's not lavish.
That's one of the reasons I didn't include all the Ubers. I quite frankly didn't want to do the math. But there were a ton of Ubers on each of these trips. There was a hotel at the beginning of the Royal Bahamans. I didn't include that. I didn't want to do the math, and I also did not want to.
And how much does Ms. Willis make?
200 and something thousand a year.
And so your
brief.
argument is that a person who makes $200,000 a year is actually setting up prosecutions to go on a trip that costs $3,500. That's your argument.
No, not in isolation. I mean, you're talking about in isolation.
No, I'm not talking about in isolation. I'm talking about what's in briefs. I don't know what else you may be speculating about. I'm just talking about what's in briefs that says this is the benefit that she got. And all I'm
Yeah.
saying is that I got a person who's making $200,000, and the benefit that you're putting into the briefs, not what you may say that you may find elsewhere, but the benefit in the briefs is I go on a trip for $3,300, $4,400.
You could put your
And they
money
made up
on.
all these prosecutions to go on a 3-day cruise for $3,300. I mean, that's your argument. If that's your argument, that's your argument.
That's not.
That's in the brief.
That's not our argument. So we did
What
argue
else is
for
in the
about
brief?
3 hours.
What else is in the brief?
What else is in the brief?
Yes.
A lot of facts, a lot of law.
No, as far as actual financial benefit.
So the financial benefit that I put in the brief was what I could prove. I did not want to have any, as you call it, speculation. I did not want to speculate about anything else. So I did not know if Mr. Wade paid for an Uber that Miss Willis was literally sitting in at the same time. You can kind of assume because it's from the airport to the hotel, but I did not want to speculate to that. So I didn't include those in the numbers. So the hard numbers in here are all of these numbers that are
That's
on
what's in
trips.
the brief.
Yes, the ones that I actually had hard numbers that I knew that she had. Yes, that's in the brief.
In our business, we deal with proof, and so that's the proof that we have.
Exactly. That's what I
That
did.
person
Yes.
is doing all of this for that.
Right.
Okay.
Oh, yeah, and
Understand.
so what I included was what I had the actual hard proof of, and then some of it's attached to the brief, some of it I got by subpoena, so some of it is actually exhibits that were admitted. I think I submitted to you all the certified business records from a couple different travel agencies. Those are actually admitted, and there were a lot of other receipts that I had that I did not know for sure if they were joined, and so I didn't include those, and I haven't
And
talked
you
about it
shouldn't,
today.
correct?
Exactly.
That's correct.
I 100% agree.
So this is what we're dealing with.
Yes, you're dealing with the stuff
Okay.
that's hard proof.
Correct. That. So my next question then becomes, going to conflict as far as his salary is concerned, just curious. Is it the amount of salary that you really creates the conflict? I mean,
Yeah, what is it?
get stuck on money a lot.
Money,
so it's the
I
amount
know.
of salary that gets is creating this conflict in your mind?
No,
Or
it's
it's
the
just the
fact
fact
that
that he gets any salary at all?
No, it has nothing to do with that. I did not make any allegations against Mr. Floyd or Ms. Cross. It's the fact that they were sleeping together and he was paying for trips for them to go on, and they were hiding it from the taxpayers.
Which we just discussed that.
That's why.
So if there's not a trip, then you don't believe there's a conflict?
Oh, I do, because of the Fulton County laws. The laws say that they
I
can.
don't understand the county codes, but I'm talking about as far as like what the case law says, which is what the judge is actually going to. If they're not hiding that or against the Fulton County ordinances,
They were hiding it, though.
do you believe that there's a conflict? If they brought it out and said, hey, we're dating, is it a conflict in your mind?
They only brought it out once I alleged it, and they called me a liar multiple times.
What I'm saying is if they brought it out, would it be a conflict in your mind?
If
Is it
they-
a conflict?
Here in a
And what would be the conflict?
So in a perfect world, what you're asking is if Ms. Willis had gone to the Board of County Commissioners and said, I'm having an affair with this man, but he is brilliant and he would be an amazing prosecutor on this election interference case. Can I have an appropriations of $3 million and I will get it done? And she had said, and I'm going to go on vacations with him and we're going to date and we're actually going to go home to the safe house that Fulton County's paying for and he's going to be here for 4 hours at night. If she had said all that and they had given what they gave in Exhibit J, knowing that, Exhibit J, we wouldn't be here.
Yeah, because she admitted.
So then your client actually has no conflict, because that would still exist. Your client has no hard conflict then. There's no actual conflict. It doesn't matter if you disclose a conflict. If you disclose a conflict, it still exists. And that's exactly what they said in one of the cases that you cited. If a person says, I got a conflict, but I'm still going to testify against you. I know I represented you, and I have a conflict, and I'm going to go testify against you. Conflict is now over. Absolutely not. If you have an actual conflict where your client is harmed, just because they disclose it doesn't
That's
end
true.
that conflict.
That's true.
So what you're describing is not a conflict at all.
No.
You're just saying, I caught somebody, so therefore I'm going to create something and call it a conflict. You cannot waive a conflict.
That's
like
what
that.
she doing.
You just could. If your client is, you could not do that for your own client. If your client is actually suffering harm, as far as how the prosecution is taking place, because that's what a conflict is. Just because she says, oh, I'm doing these things, you're not going to go to your client and say, you actually have actual harm, but she said it, so we're going to still go forward. That makes absolutely no sense.
I'm sorry, I don't understand your question to me. I don't know what
You
you're
don't
asking.
have a conflict. If
You
you're
don't
saying
have
she
a
disclosed
conflict.
It will go away. Then there is no conflict.
No, I did not say that. I said we would not be here if that had happened.
Right,
That's
because
what I
you
said.
wouldn't claim there's a conflict.
No, because we wouldn't be here because it violates so many of the Fulton County statutes and ordinances and the state statutes that we wouldn't be here because it wouldn't have been approved.
But if she disclosed it, not the way you said it,
If
but if it was disclosed, now what is the conflict?
The undisputed facts, the facts that we all, your side and my side.
How's
the
your
other
client
side.
harmed? That's my question.
Hold on, I'm trying to answer your first question now.
Come on, honey.
If all the undisputed facts, if those had been in front of the Board of County Commissioners, we wouldn't be here because there would not have been a contract, because it's in contravention of law. So we would not be here. I would not be bringing a motion because who knows if my client would have been indicted. Now, I wish we could go back in time and undo that and see, but we can't. And so Mr. Wade was in the jury. He should not have been there. He should not have been appointed. Had the Board of County Commissioners known all of the facts of the case, he would never have been appointed to this case. So we can't now speculate as to what could have happened.
What case law do you point to prove that?
Yeah.
Oh, the statutes.
No, it's not a statute. Not Fulton County statute. I'm asking for Georgia Court of Appeals, Georgia Supreme Court. Is there any case that says that? And there's not.
No, and it's really not surprising, honestly, because can you imagine this happening? I mean, honestly,
happens.
in December, would you have imagined this happening? I think most people wouldn't
All
have.
sorts of conflicts are taken up by the Court of Appeals.
I can tell you, I have found some cases in
She
other
making up
jurisdictions,
stuff.
but I have never found a case in Georgia where, and mind you, this only happens in Fulton County. So we're talking about Fulton
my
County cases
goodness.
where there would be a special prosecutor appointed, because it's the only place that this happens. So otherwise, maybe the AG. So you're talking about a prosecutor sleeping with the person that she is appointing to do this work, paying exorbitant amount of money, not getting county approval, not filing.
Is she paying him, or is he earning the money because he's actually billing hours because he's prosecuting the case?
I mean, I don't,
He's
I wasn't
billing hours
there.
because he's prosecuting a case, correct?
I
A case that a
would
grand
assume.
jury indicted.
I would hope that he's billing based on work that he's doing. I don't know because I don't have proof of that, and the billing is very irregular. But I don't know, so I don't.
But I mean, words
speculate.
do matter when we say that she's not paying him in that
That's
sense.
right.
He's earning money
You're
for a
right.
case that he's in charge of prosecuting, that a grand jury indicted, and that's where we are.
You're
That's-
correct. She is not paying him. The Fulton County taxpayers are.
As they pay every prosecutor, as they pay every public defender, and every government official that actually exists.
Employees, yes.
100%. And that he is part of that process. And he is prosecuting a case that you're involved in, correct? He's prosecuting, and he's been integral in that prosecution. And you've said that.
I mean, he has been very involved. Integral to me means that he is necessary.
Senator Jones, are you getting close?
Yes, sir. I just had one last question, and that was, in the case that you cited, it clearly says,
Which case? I'm sorry.
in
Whitten?
Whitworth versus State, it clearly says, the prosecutor should see no unfair advantage in taking advantage of the accused. That creates the conflict. What unfair advantage has he done in this case?
And you've asked me a lot of questions about Whitworth. I would love a chance to read it if you have a few minutes, just so I can actually respond. I don't have it in front of me, and there's a lot of cases out there, and I want to make sure I respond accurately.
Sure, I have it.
Okay. Nice.
Yeah, absolutely.
Thank you. I'm sorry. I'm one of those people on visual. I like to see it. Do you mind?
Well, some
Thank
stuff
you.
that you don't need, you didn't have visual.
While she's looking at this, we're going to wrap up here in a few minutes. I wanted to let the public know how you can get information to us. Each senator on the committee has a separate email address for committee business, and it's simply the last name of the senator. In my case, it would be counsel.inv@senate.ga.gov. INV, obviously, for investigation committee. So each senator, their last name, .inv@senate.ga.gov. And David Cook is sitting over here in the corner as the Secretary of the Senate. He is going to be the safekeeper of any documents or evidence that we accumulate. His email address for this purpose will be cook.inv@senate.ga.gov. I've had a number of citizens that have reached out and wanted to provide information or be heard or testify possibly in front of this committee, and we are
Oh, now she
encouraging
want to come
anybody
in
that
after
has
everybody get ready to
input or
leave.
information that might be helpful to us to provide it to a committee member, ideally to cook.inv@senate.ga.gov, because Secretary Cook will provide it to all committee members. We don't have a next meeting scheduled yet, but it will be
This was very
no more than a
interesting.
couple of weeks away. Ms. Merchant, you may not be able to have completed your testimony today, and we may have to call you back for additional questioning after today, but I'm not rushing. Take your time, read that.
Can it not be the first week of April?
Yeah.
Cobb County spring break, please.
Spring break, baby. You ain't lying. I can't wait.
Okay, yeah, no, I'm so glad. So this is Morgan. When you said Morgan, it should have, J-Tom, it should have struck with me. I remember this now. So this case, so J-Tom was actually the district attorney when he first took this case, and he was not.
Don't talk while you...
Oh, I'm sorry, I forgot the microphone. Not good at that, sorry. He took employment later on. So the employment, so it's different than our case because he took employment later on. He wasn't actually paid hourly. He was a member of Prosecuting Attorneys Council. And I'm glad you brought that up because that was one thing that I didn't really go into earlier. The other way that counsel is usually appointed in these cases is the Prosecuting Attorneys Council actually appoints it. And that's what happened in that case. But they sometimes will pay an hourly rate if it's something that is needed. But in that case, he was actually the district attorney in another county. And that's what I've experienced before. So the 2 times I've had special counsel, it's been because it's somebody from outside in another jurisdiction that's brought in. So that's what happened in this case. But then he took a job later. The other big difference with that case, and this came up in our oral arguments with the judge, that's a post-conviction case. The standard of review is very different post-trial than it is pre-trial. We're in a pre-trial posture. And we talked about that because the judge asked us a similar question about how to distinguish that. That's the big issue. And the judge pointed that out. That is post-trial. Post-trial, we have harmless error review. It's not a great review. So, it's just like ineffective assistance of counsel. If you stop the harm before it happens, it's a different review than if you fix the harm after it's already done. It's really hard to overturn a conviction once the conviction happens. And that's what you have there.
But in this case, they never got to the harmless error because they said that no conflict existed. I understand what you're talking about by the harmless error, but they never discussed that because no conflict existed. And you're right, it is post-conviction, but bottom line is, you really did not address the aspects that I was talking about when they say is a conflict. And it's not me putting this case in talking about a conflict. It was the case that you guys actually did cite. With that, Mr. Chair, I yield.
Well, can I at least answer that question?
Sure you can.
We definitely cite it because we have, both myself and my husband have a very strong policy of citing everything. We don't hide cases. So if there's something that's adverse to our position, we're going to cite it and we're going to explain it. We don't hide behind it. So we cite adverse authority all the time.
Adverse authority, but that's fine.
The oral arguments that we did, that was how the oral arguments started. So.
All right, so that line of question deals specifically with the legal principles involved in your motion to disqualify. As I understand it, you're not really claiming a conflict of interest between defendants, et cetera. It's the conduct of the prosecutor.
Yes.
That
Yeah, there's
is
no
improper
conflict.
Conduct.
Yeah, we're not talking about the conflict between defendants.
We're talking about the fact that the DA's office failed to follow state law and get an approval, failed to follow county policies to get approval of her budget and this contract, that he was not eligible to have been hired had he been disclosed because of, you referred to it as nepotism, but it's relationships with, and your complaints
You talking
are,
about that?
she's receiving a
Not the
financial
lady.
benefit of
I
gifts
think
of more
I think
than
the lady
$100,
just
which
followed.
violate county policies.
Yes, county and state. So and we attached that to one of the briefs.
I think she's just doing her job.
Return where she filed it under oath that says,
Okay.
I mean, it specifically says if you've got something over $100, you have to.
It's not really
You have to disclose it.
And
Here it is. It's so it's called the Fulton County Income and Financial Disclosure Report, and that says, and it says pursuant to Section 2-79 of the Fulton County Code of Ethics, that anytime you've got each gift or favor from a single prohibited source in the aggregate amount of $100 or more. And then it says, for purposes of this section, gift and favors means anything of value given by or received from a prohibited source. Prohibited source means any person, business, or entity that the involved officer, so Ms. Willis, knows or should know is seeking official action or seeking to do or doing business with the county. So obviously that would apply.
Okay. And failing to respond to your open records request and potentially giving false testimony under oath if your version of facts is proven to be true.
Yes.
Okay. Keep us posted. I guess we'll keep reading the press as to how your case progresses, I guess there. I'm troubled about this Find the Votes book. Are you saying that the prosecutor has been discussing an ongoing prosecution and her prosecutorial strategy and indictment strategy to authors of a book during the course of the prosecution?
Yes.
And
yes.
that book has now come out?
It is. I think I brought it with me. No, I have a copy. We admitted a copy at the hearing. No, it's out there. It was published,
Is that a violation of ethical obligations in some way to be publicly discussing, just like the public statements you made about the guilt of a defendant, et cetera?
Yes, definitely. And we alleged that and argued that as far as forensic misconduct. It's very surprising, shocking, and I don't know that there's a ton of cases on it. But that book, Also, we talked about it somewhat in our hearing because it goes into a lot of details about the financial troubles that Ms. Willis had prior to becoming DA. And so, it talks about that a lot.
Okay. Is she getting a financial benefit from that book?
I don't know.
Is she getting a royalty or a payment for having been a contributor to it?
I have no idea.
Okay.
But I know her dad testified that he was interviewed for it. He came to the district attorney's office and was interviewed for it as well. And I think that was when her dad first learned that she had dated Mr. Wade, I think. But I may be wrong. Or maybe that's the first time they met, something like that.
All right. Well, thank you for your willingness to testify before us, and the documents you provided. We'll need some time to analyze and review those. And again, all committee members have access to those. At David Cook's office, he's got them literally locked up in a room. We are not making copies or disseminating those. I will review the documents in more detail, and I'll confer with you, Senator Jones, if you're able to. We might can agree on what should be kept confidential there. I noticed some bank records and things that if it were me being investigated, I probably wouldn't want it divulged to the public. I don't think that's necessary for us to do our job here. I do appreciate everybody's attendance, and thank you all.
And y'all, and I appreciate y'all being here today too. That we learned that listen to the testimony that at the hearing, that it's just not the fact that Ashleigh is a tough attorney. It's just like she is not making a conflict out of what had happened, what have happened. She just stating that what happened was wrongdoing. If the way that Fani did everything that she did is wrong. It's wrong. That's what she's trying to say. It is not easy to face such level of questioning and yet seems so prepared. Well, the thing, she has to be prepared because she's an attorney. She has to be prepared. But I can understand what she's saying. I understand what she's saying, and I understand what he's saying. And she is not worried about the conflict of anything. She's worried about the thing that Fani wasn't supposed to be doing at that time. It's a lot to this, and we have to stay on it, y'all. So that's why they having so many different hearings. So today you all seen the Senate, the Senate committee, and to be honest with you, to be a female, to be in front of these men, she did she knew what to say. She's an attorney. She know her job. But I don't think that she want to deal with the conflict of the situation. She not trying to confront conflict. She just trying to put things in place with things that you're not supposed to do as a DA. If you're wrong, but now that this comes for the disqualification, come up being disqualified, should she be disqualified in this case? I would say deep down in my heart, I don't think she should be qualified to move forward with this case. I said this before. I said it once and I said it again. I don't think that she should be disqualified. That's just me. I don't know about nobody else. To me, she should be disqualified to be working this case, or either she can be partial of the case. Because the case to me don't seem like it has nothing to do with Trump. You see what I mean? What is it? Where about have this had something to do with Trump? So my thing is, if if that decision, this don't make no sense. This really, this situation right here doesn't make no sense. It's about a divorce. It's about, she didn't abuse the money. She didn't abuse the money because that was Wade money. That was Wade money. The people is paying those folks sitting up there. The people paid Wade, not Fanny. So because he was an employee. So it's not like even if you get some percentage out of it, she put it back. Y'all do that every day. Y'all do that every day. But you're not supposed to do that. That's why you have an audit. Anything where it got money coming out or something, you have an audit of somebody who run the money, the situation, the layout. You know, it's supposed to be on paper. It's not nothing that Fani Willis and Wade have done in their office should be a hearsay. It should come off of an audit. It's supposed to come out of paperwork. You're supposed to be able to put paperwork to show what you did, how you did it, when you did it. It's supposed to be on paper. So I appreciate y'all being here. We're gonna stick on this hearing. And y'all enjoy the rest of y'all day. I want to thank my mom for doing an outstanding job. Thank my viewer for watching and your participation. You know, I appreciate y'all giving me the thumbs up in this case. I've been with this case from the beginning. I'm gonna stick with this case from the beginning. I'm out of here, y'all.